Today we will be discussing about important media laws. And the laws which we will be touching upon are the Indian law of defamation, the Indian law of contempt of court, the Copyrights Act, and right to intellectual property. Article 19(1)(a) of the Indian Constitution guarantees us the freedom of speech and expression, which means we, the citizen of India, have the right to express our opinions, express our views regarding any subject or circumstance. But while saying so, it should also be remembered that this right is not an absolute right. There is also Article 19(2) of the Indian Constitution, which imposes certain reasonable restrictions on Article 19(1)(a). For example, the law of defamation, contempt of court, Official Secrets Act, and many others. It is important for journalists to have a firm knowledge on these subjects, simply because a journalist should not only be ethically correct, but also be legally correct. So let us start with the first subject, that is the Indian law of defamation. The Second Press Commission of India have defined the Indian law of defamation as a tale of two interests. On one hand is the interest of the individuals, corporations, groups, organizations to live or work with absolute reputation. But at the same time, on the other hand, is the right of the citizens to know the truth, to know what goes on behind the curtains. A journalist is a watchdog of a society. This calls for a huge responsibility. A responsibility, like I said, not only to be ethically correct with facts, but to stay within the legal parameters. A journalist should not write or publish or comment anything defamatory unless he or she has got ultimate evidence and proof that the things has been done. Evidence, truth, followed by verification. Defamation is dealt under Section 499 of the Indian Penal Code. It defines defamation as whoever, by words either spoken or intended to be read, or by signs or by visible representations, makes or publishes any imputation concerning any person intending to harm or knowing or having reasons to believe that such imputations will harm the reputation of such person is said to defame the person. This definition has got four explanations. Number one, to impute something on a dead person, which hurts the reputation of that deceased person or affects his family, relatives, friends, associates, etc. Explanation number two, to impute anything concerning a company or an association that damages their reputation. Number three, to impute anything on an individual or group in the form of an alternative or expressed ironically. But while saying so, point number four comes in that says, unless the imputation directly or indirectly lowers the moral or intellectual character of that individual, it will not amount to defamation. Under Section 499, defamation has got two types, and they are slander and libel. Slander, simply speaking, is spoken defamation, whereas libel is written or published defamation. Therefore, it can be easily understood that cases of slander are difficult to prove because that calls for evidences. Whereas since libel are written, documented, published notes, articles, or any such printed matter or published matter, proving of such cases are relatively easier than the cases of slander. Libel again has got two types, libel per se and libel per quod. Libel per se is direct defamation, making a statement or publishing or writing any such matter which is directly derogatory. Whereas libel per quod means indirect defamation, where the person is not saying or speaking or writing any direct derogatory words or sentences, but writing anything concerning another person which may indirectly lower the reputation of that person in the society or organization. The Indian law of defamation under section 499 has got a list of 10 exceptions. Anything which is true, and anything which is for public good, and anything which is expressed in good faith will not be accountable as defamation. At the same time, reporters or anybody can criticize a public servant as a public servant, which means you can criticize a public servant regarding his duties as a public servant. You can also criticize anybody if his or her conduct touches any public question. This is exactly the area where reporters criticizes the various MPs, MLAs, etc. People who are responsible for certain public works, whose conduct are related to certain public questions, they can be criticized about those public questions. At the same time, publication of substantially true reports of court proceedings will not be accounted for defamation, provided, as I said, substantially true reports, which means the reporter in no way is changing the facts or is misinterpreting whatever has been said or documented in the court. With this closely comes the next exception, which says it is not defamation to publish merits of cases decided by the court or conduct of witnesses or others concerned, provided the case is closed. But while saying so, it should also be remembered that a reporter cannot criticize a judgment. Well, they can write about the merits and demerits of the laws based on which the judgment has been delivered. Merits of public performances which its author has submitted to the public judgment is not defamation. Simply speaking, it means a reporter can review a film, they can review a book, they can review a music CD. And even if the review is not a positive one, even if the review is not liked by the producer, they cannot file a defamation suit provided the reporter is not writing anything concerned about the character or conduct of that producer. It is not defamation to pass censures in good faith by a person on another having lawful authority over him or her. Simply speaking, it means a subordinate can criticize the boss. While saying so, the next exception is just the vice versa. A boss can criticize his or her subordinate. Imputations made in good faith by person for protection of his or her or others' interests will not be accountable as defamation. And lastly, caution intended for good of persons to whom conveyed or for public good will not be defamation. This is exactly the area where reporters can express caution to political parties, they can express caution to various leaders. While we are discussing defamation, I am very sure many of you will remember the famous case between Justice P.V. Sawant and the Times Now group, where the group had mistakenly shown a photograph of Justice P.V. Sawant in one of its news coverage, and Justice Sawant filed a case against them. The channel was asked for a damage of rupees 100 crores, one of the most famous cases of defamation in recent times. Another case which caught public attention was the case between mathematics teacher Uma Khurana and the Live India group. The Live India group had carried out a sting operation on the teacher, saying that she was involved in a case of human trafficking. The day the case came out, she was heckled by the public and was arrested by the police. She filed a charge of defamation, and it was proved that the journalist who carried out the sting operation had not carried out it in good faith. In fact, the allegations were all wrong. The journalist was arrested, though Ms. Khurana came in terms with Live India group and the case was settled. Another case which caught public attention in recent times was the case between ex-Law Minister Salman Khurshid and his wife Mrs. Lucy Khurshid and the India Today group, where the minister and his wife was accused of misappropriating government funds in an NGO. They had filed a 1 crore defamation suit against the India Today group. It was in 2012. Later, the case was withdrawn, and the case came to an end with expression of mutual regrets from both the parties. With this, we come to the end of the Indian law of defamation, and the second law that we are going to discuss about is the Indian law of the Contempt of Court. What is this law that deals with the contempt of court? It is a set of law which restricts and or punishes people from disrespecting or disobeying a court's order, interfering with trials and due course of justice, or misinterpret communication that happen inside a courtroom. It is exercised to protect the administration of justice from being maligned. Contempt is any conduct that brings or tends to bring the authority and administration of law into disrespect or disregard or interferes or tries to interfere with the parties, the trial, or that tries to prejudice the case or the witnesses during litigation. Every court of India promises a free and fair trial, and it is just because of this reason that the contempt of court law is absolutely important for journalists to have a firm knowledge on, because many a times journalists have to report court cases. In the wake of media activism, this has become more important. If you remember, journalists were almost carrying out a parallel set of investigation in the Nirbhaya case and same in the Jessica Lal case. This is exactly the ground where a journalist should know where to draw the line. According to the Indian law of the contempt of court, there are two types of contempt: the civil contempt and criminal contempt. Under Section 2B of the Contempt of Courts Act of 1971, civil contempt has been defined as willful disobedience to any judgment, decree, direction, or order, or writ, or other process of a court, or willful breach of an undertaking given to a court. The second type, that is criminal contempt. Under Section 2C of the Indian Contempt Law, criminal contempt has been defined as the publication, whether by words, spoken or written, or by signs or by visible representations, or otherwise, of any matter or the doing of any other act which, number 1, scandalizes or tends to scandalize, or lowers or tends to lower the authority of any court, or prejudices or interferes or tends to interfere with the due course of any judicial proceedings, or interferes or tends to interfere with or obstructs or tends to obstruct the administration of justice in any other matter. Simply speaking, civil contempt means willful disobedience, that is, say for example, the court has given a particular order and the journalist disobeys the order. That falls under civil contempt. Whereas, if the journalist reports anything, interviews the witnesses, tries to interfere by proceeding documents or whatsoever, which may interfere with the due course of justice, that might amount to criminal contempt. Journalists should also have proper knowledge on the penalties that they might face. Under Section 12 of the Contempt of Court Act 1971, a contempt of court can be punished with simple imprisonment for a term which may extend to 6 months, or with fine which may extend to 2,000 rupees, or with both. This is particularly important for journalists because many a times journalists report under trial cases. The problem becomes more in case of translations. Every language has got a different essence. A word spoken in English, when translated in Hindi or in any Indian language, a little bit of difference in the meaning associated might occur. And this is exactly the area where the overall meaning of the things spoken in the court or the documents produced might get altered. The best thing to avoid such a problem is to directly quote the judge or any party involved and to avoid any scope of misinterpretation, and that is exactly what journalists do. They simply quote whatever has been spoken in the court. In the era of rising trial by media, every house carries on with investigative journalism, and many a times, investigations parallel to police investigations are carried out by journalists. Many of you will remember, during the Nirbhaya trial, a section of the jury as well as the Delhi police had wanted to put a stop on such media activism. But the Honorable Supreme Court was not in that favor, and the Honorable Supreme Court had allowed the media to carry out their own investigation, but with due care and only for public good. Many of you will remember that ace journalist Madhu Trehan, when she was the editor of the magazine Wah India, had conducted a survey among senior advocates in the Delhi High Court, asking them to rate the judges of the Delhi High Court on a number of factors, and published the result in the magazine. She was charged with a contempt of court case. However, later she had expressed apology and she was relieved. This means, before a journalist carries out with any reporting on court, on the judge, on the jury, which might lower or tend to lower the respect, the reputation, or the authority of a court, should be ultra cautious that he or she might fall within the parameters of the Indian law of contempt of court. While saying so, it is also important to note that both in case of defamation as well as in contempt of court, there is a provision of postponement of media reporting, which means the court can ask the media not to report a particular case on that particular time, but hold on and report the case later. This had happened in the case between Shahara India Real Estate Corporation Limited and others versus Securities and Exchange Board of India and others in 2012, and also it happened in January 2014 when Justice Swatantra Kumar was accused of sexual harassment by a law intern. In both cases, the court had asked for postponement of media reporting. Now we come to the third section that we are going to deal with today, and that is the Indian Copyrights Act 1957. What is actually this copyright law all about? Copyright is a collection of rights given to the creators of artistic works like literature, drama, music, as well as cinematograph films, etc. The copyright law provides the right of reproduction of the work, communication of the work to the public, adaptation of the work, and translation of the work. Simply speaking, it gives credit to the creator of that intellectual work. Under the Copyrights Act, it is the author of the work who owns the copyright. However, if the author is employed under another entity, and in the absence of a contract between the author and that particular entity, the copyright belongs to the entity and not the author. According to the Indian law of copyright, copyright stays with the author throughout his or her lifetime, and after his or her death, the copyright stays for another 60 years. Thereafter, the work becomes copyright free. In case of cinematograph films, sound recording, posthumous publications, works of government, works of international organization, copyright stays for 60 years. In this regard, I must state that Gurudev Rabindranath Tagore, since he passed away in 1941, the copyright of all his works stayed with Vishwabharati till 2001. This means a producer or a director who would have intended to work with one of the novels or one of the poems of Gurudev Rabindranath Tagore would have to sort a copyright from the Vishwabharati pre-2001. But now it's free. However, like all other acts, copyright too has got a number of exceptions. Number 1. Non-commercial and personal use. That does not account for copyright infringement if one is using it. Number 2. Use of any copyrighted material for academic purposes as well as for research and development. Number 3, which is important for journalists. Criticism or review. Like I said before, if a journalist gives a bad review to a particular film or to a book, neither the producer can charge him for defamation, nor is the reporter infringing copyright, provided the producer has submitted the work for public judgment. Point number 4. Reporting of current events and current affairs, including reporting of lectures delivered in public, does not account for copyright infringement if they are being reproduced in newspapers by journalists. However, all these exceptions depends on one point: whether the publication of such is hampering in any way the market value of that particular creation. It's especially important for journalists to have a proper knowledge on copyrights. The simple reason being, reporters often use references of others' work. Reporters often use quotes from others' work. In fact, reporters often use pictures, drawings, paintings, like I said, references from others' work. They must know the limit to which they can be published or reproduced so that the market value or the commercial value of the original work is not negotiated. In case of infringement of copyright, which again is important for reporters and journalists and media persons to know, penalty can be imprisonment, which can go up to 3 years, and fine, which can go up to rupees 2 lakh, or it can be both. Coming to the last point of today that we are going to discuss, and that is the right to intellectual property. The intellectual property rights in India mainly covers copyrights, patents, designs, trademarks, and geographical indications, are all giving credit to the creators of intellectual properties and giving the right to them to earn commercial benefit from their own creations. Therefore, when a reporter writes something, covers a new innovation, a patented material, they must keep in mind that they are not infringing the owner's patent rights, they are not violating the trademark rules, they are not tampering with or misrepresenting industrial designs. Similarly, with items which has got geographical indication tags, proper credit to those geographical indications should be given. Points that should be kept in mind: a reporter should not report about an innovation before it has been applied for a patent. A reporter, while reporting on cases, for example, currently a debate going on over the origin of the Bengali sweet Rasgulla, whether it originated in Bengal or in Orissa, they must give due coverage to both sides so that while a case or while a decision is on regarding geographical indications, the parties or the judgment authorities are not biased. With this, we come to the end of today's discussion on important media laws. But every aspiring student of media or professional of media must remember that he or she is a responsible citizen of the country first and a professional later. So while being legally correct, the reporter is not only being true to the profession, but he is being true to himself or herself, and that is what is most important.